The phone rang at 9:14 in the morning on a Tuesday in March. The caller ID said, Texas Health and Human Services. Margaret Castillo was standing in the kitchen of the house her late husband built, the house her 3 children had grown up in, the house that had been paid off for 11 years, no mortgage, no line of credit, no liens of any kind. She almost did not answer. 47 days earlier, she had buried her husband, Robert, 68 years old, retired pipe fitter from the Dow chemical plant in Freeport, a man who had worked overtime for decades so that the home note could be burned early. They had a mortgage burning party in the backyard in 2013. The kids had made a fake mortgage document out of cardboard and put a lighter to it. Everybody laughed. Robert said that day that no one would ever take this house from his family. Now Margaret was being told that someone was about to try. She answered the phone. A polite woman on the other end introduced herself as a caseworker with the Texas Medicaid Estate Recovery Program. Margaret did not know what that meant. The woman explained that Robert had received long-term care Medicaid benefits in his final months. He had spent the last 94 days of his life at a nursing home in Lake Jackson, Texas. The total Medicaid bill for his care was $312,400. Then the woman said a line that changed Margaret's life. Ma'am, the state of Texas is required to recover those costs from the estate. We will need to place a claim on the house, the paid-off house. The house Robert had promised no one would ever take. Margaret sat down at the kitchen table. She stared at the empty coffee mug her husband had used every morning for 41 years. She did not speak for almost a full minute. Then she whispered one sentence. The same sentence in one form or another that I have heard from families all over this country when they finally understand what just happened to them. She said, but the house was paid off. If you are watching this and you have a paid-off home, or your parents have a paid-off home, I need you to stay with me for the next few minutes, because what happened to the Castillo family is not rare. It is not a fluke. It is a quiet system that operates in every state in America, and it is built into the rules of a program called Medicaid. Most families never hear about this rule until it is too late. By the time the letter arrives, the math has already been done. If this story hits you in the gut, hit like now, because more families need to see this before it happens to them. And send this video to one sibling tonight. One conversation now can save a house later. My name is not important. What matters is that I am going to walk you step by step through what just happened to the Castillo family. I am going to do the math out loud. I am going to explain the rule in plain English. And I am going to show you the legal moves that real families use to keep a paid-off home in the family before the letter ever arrives. Let's start with Robert's last 94 days on Earth, because that is where the trap quietly closed. Robert Castillo had been a strong man his whole life. He worked the pipe yards at Dow from the age of 19. He retired at 62 with a small pension, a modest 401k, and the house his overtime had paid off. He and Margaret had 3 children. Daniel, the oldest, was a high school teacher in Houston. Lillian was a nurse in Sugar Land. Michael, the youngest, was still in Galveston, working 2 jobs and renting a small apartment. In November of the year before everything collapsed, Robert started forgetting things. At first it was small, the brand of coffee, the day of the week. Then it got bigger. He forgot how to drive back from the Walmart. He forgot where the church was. He forgot Lillian's birthday, which had never happened before in 42 years. Margaret took him to a doctor in January. The diagnosis was brutal and quick. Early onset Alzheimer's, steady decline, no cure. By February, Robert needed help getting dressed. By March, he could not be left alone. Margaret, who has her own blood pressure and knee problems, was exhausted. Daniel came down from Houston on weekends to help. Lillian drove in from Sugar Land when she could. On the night of April 7th, Robert fell in the bathroom. He lay on the tile for almost an hour before Margaret heard him through the baby monitor she had set up by the bedroom. The ambulance took him to the emergency room in Lake Jackson. After 3 days in the hospital, the doctors were blunt. He could no longer live safely at home. He needed a nursing home, full-time. The social worker sat Margaret down and asked a simple question. How are you planning to pay for this? Margaret, like most American families, did not have an answer. Robert's pension was about $2,900 a month. Their savings were around $94,000. A private nursing home room in Brazoria County was running between roughly $7,000 and $11,000 a month at that point, numbers consistent with the Genworth/Care Scout 2024 Cost of Care Survey, which put the national median around $315 per day for a semi-private room and $355 per day for a private room, with Texas running noticeably below the national average. That means a single year of private pay care would easily cost more than $94,000. The most expensive year would cost over $130,000, and Robert most likely had years ahead of him, not months. The social worker said the words that millions of American families hear every single year. She said, "He probably qualifies for Medicaid. Medicaid can pay for the nursing home." Margaret felt something like relief. Medicaid would save them. The house would be safe. The kids' inheritance would be safe. They had made it. Robert's overtime had saved them. But here is the line nobody said out loud that day. The line that lives in the fine print of a federal law called the Omnibus Budget Reconciliation Act of 1993. That law requires every state Medicaid program to try to get the money back after the person dies. The official name is Medicaid Estate Recovery, often abbreviated MERP. Texas runs its program through the Texas Health and Human Services Commission. They call it the Medicaid Estate Recovery Program, and they have a whole department for it. In plain English, that means this. When a person on Medicaid dies, the state is allowed to come back to their estate, look at what they owned, and ask to be paid back for the care the state paid for. The state does not send flowers to the funeral. The state sends a bill, and in most cases, that bill lands on the one asset the family thought no one could ever touch, the paid-off home. Let me say that again, because this is the part most people never hear. The home you paid off, the home your father sweated for, the home your mother raised you in. If your parent received long-term care Medicaid after age 55, the state can, after death, place a lien on the probate estate to recover those costs. That is not a theory. That is the law in Texas, in California, in Ohio, in Florida, in New York, in every state. The exact rules are different in every state, and we will get to that. But the basic idea is the same. The state paid for the care, the state wants the money back. Now let me show you the math on the kitchen table, because the math is what makes this feel real. Medicaid estate recovery in Texas does not stop at the last few months of life. According to the official Texas rules and the KFF overview of the program, the state may recover for long-term care services, related hospital costs, and prescription drug costs paid on behalf of the recipient after they turned 55. Most Americans do not know that. They think Medicaid is helping grandma now, and they figure the estate recovery thing only applies to the last few months of life. It does not. It can go back years. Let's do the realistic Castillo math. Reimbursement rates paid by Texas Medicaid to nursing homes for long-term care residents have hovered in the rough neighborhood of $200 to $280 per resident per day in recent biennium updates, using a round figure of about $225 per day for Robert's 94-day final stay. That is around $21,000 of recoverable nursing home spend on the last admission alone. But before that final stay, Robert's Alzheimer's had been getting worse for more than a year. He had multiple hospital stays in Houston for infections and falls. He had prescription drugs at Medicaid rates. Add it all up, and a fair realistic figure for total Medicaid spend on Robert Das, including prior hospitalizations, prescription drugs, and the long final nursing home stay, could easily climb to $150,000, $200,000, even $300,000 or more. The $312,400 number the state quoted Margaret on the phone is consistent with several years of serious decline with multiple hospitalizations. That is not unusual. That is average for a long-term care patient in Texas. So here is the math the Castillo family did not run until it was too late. Robert's pension of $34,800 a year was not nearly enough to pay a private nursing home. Medicaid stepped in. Medicaid paid roughly $300,000 of care. Medicaid was the reason Robert was not thrown out of the facility to die, in the most generous sense. But Medicaid was also a loan with no paperwork signed, a loan with no interest rate quoted, a loan whose collateral was everything Robert owned when he died, with the house at the top of the list. When Robert died, Medicaid sent the bill. The state's claim was around $312,400. The house was worth about $440,000 at the local market. Margaret owned the house jointly with Robert, which means when he died, his half of the house passed through probate. In Texas, Medicaid can recover from a probate estate, and in many cases can also pursue against property that passes outside probate where state law and federal rules allow it. The family was facing a Medicaid claim that could swallow a huge portion of their largest asset. Let me pause here. I want you to feel the size of that number against the kind of family Robert was. Robert was not rich. There was no trust fund. There was no rental empire. There was no offshore, no rental empire. There was no offshore account. There was a pension, a savings account that had been quietly growing, and one house in Lake Jackson. That was it. That was the entire Castillo family wealth. And now the state had a claim on most of it. Now let me explain how the system actually works, in the simplest terms I can. Step 1. Someone you love has a long-term care event. It might be Alzheimer's, it might be a stroke, it might be a fall that leads to a hip replacement that goes wrong. The trigger is the same. They need full-time care in a nursing home or an assisted living facility with a Medicaid contract. Step 2. The family applies for long-term care Medicaid. To qualify, the applicant must meet income rules and asset rules. The income limit in most states for a single individual in 2024 was roughly in the $2,800 per month range, depending on the state. The asset limit is usually around $2,000 for a single applicant. A married couple gets more protections. Step 3. If the applicant has too much money, the family spends it down. If the applicant has a paid-off home, that home usually does not count against them while they are living in it, or while a spouse, a child under 21, or a blind or permanently and totally disabled child lives in it. This is the part most people understand. The home is usually safe while the person is alive, so families relax. They think this is over. Step 4, the applicant eventually dies. And here is the trap that quietly closes. The moment the applicant dies, the home exemption for the deceased ends. The state now looks at the probate estate. The state files a claim. The home is usually the largest asset in the probate estate, so the state gets paid out of the proceeds of that house. That is the entire system. That is the engine that quietly takes paid-off homes from middle-class families every single year in America. Let me explain the look-back period too, because this is the rule that gets families in trouble even before death. The Medicaid look-back period for long-term care is 5 years, 60 months. That is the federal rule for almost every state. In plain English, that means this. Every time you apply for long-term care Medicaid, the state looks back 60 months into your financial history. They look at every transfer, every gift, every sale below market value, every money movement. Anything you gave away for less than fair value inside that 5-year window can trigger a penalty. The penalty is a delay in getting Medicaid. For every dollar you gave away in many states, the penalty adds up to roughly a month of Medicaid coverage per several $1,000s of transferred value. The exact divisor depends on the state, and the math changes every year. Let me show you what that does to a real family. Your mother gave her grandson $25,000 in 2022 to help him with a down payment on a first home. 3 years later, your mother needs a nursing home and applies for Medicaid. The state looks back 5 years. They find the $25,000 gift. Depending on the state's divisor, that translates to several months of penalty. Your mother must pay out of pocket for those months of nursing home at private rates before Medicaid will kick in. $25,000 to $35,000 out of pocket, depending on the facility. That one loving gift just cost the family $30,000. This is the look-back period in plain English. It is a rule that punishes families for being generous. It is a rule that treats love like a financial crime. But the look-back period is not the only trap. The bigger trap, the one that took Robert's house, is Medicaid estate recovery after death. That is where most families feel the pain. Let me talk about why the paid-off home is the favorite target. It is not because the state hates homeowners. It is because the home is the biggest, most identifiable, most easy to liquidate asset in most estates. When a Medicaid recipient dies, the state has a claim. The state wants money. The home is sitting there. The home is worth hundreds of thousands of dollars. The home is exactly what the state needs to satisfy the claim. Now let me talk about what most people believe and how that belief gets them in trouble. Most people believe the house is safe. They believe it because the house is paid off. They believe it because their parents lived in it forever. They believe it because nobody ever sent them a letter saying otherwise. And they believe it because when they sat down with the nursing home social worker, the social worker smiled and said, "Don't worry, the house is exempt." Here is the hidden lie. That statement is half true, and that is what makes it so dangerous. The house is exempt while the Medicaid recipient is alive. The house is exempt while a spouse lives in it. The house is exempt while a child under 21 lives in it. The house is exempt while a blind or totally disabled child lives in it. But the moment the recipient dies, the exemption ends for their half of the house. The Medicaid estate recovery claim attaches. Let me say it again, because this is the single most important sentence in this entire video. Your home is exempt from Medicaid while you are alive. Your home is not exempt from Medicaid estate recovery after you die. That sentence is the difference between a paid-off house that stays in your family and a paid-off house that gets sold to satisfy a state claim. If you have ever heard someone say that the nursing home took their parents' house, that sentence is what they did not understand. Now let me talk about Texas specifically because the Castillo family lived in Texas, and the rule has some Texas flavor. Texas, like most states, runs an aggressive estate recovery program through the Texas Health and Human Services Commission. The state's automatic exemptions include a surviving spouse, a surviving child under 21, and a surviving child of any age who is blind or permanently and totally disabled. Texas also has a separate exemption for homesteads under roughly $100,000 in equity, where the heirs have limited income. Texas has a small estate floor. According to Texas Law Help and HMS Holdings' published MERP guidance, the state generally does not bother with claims against estates worth $10,000 or less, or where the recoverable amount is $3,000 or less, or where sale costs would leave nothing meaningful to recover. But if those exemptions do not apply, and the state has a claim above those floors, the state files a claim in probate court. The claim becomes a lien against the house. The house cannot sell cleanly. until the claim is resolved. The kids want to sell the house, they cannot. The kids want to refinance, they cannot. The kids want to live in the house, they may have to buy out the state's claim. Let me run that math for you. House value, $440,000. Medicaid claim, $312,400. That leaves around $127,600 to split among the heirs, minus closing costs, minus probate fees, minus attorney fees. If probate drags on for a year or 18 months or $2, and national surveys consistently put average probate timelines somewhere in that range, the family has been frozen out of their own asset for a long stretch. And that is not counting the emotional journey of losing the person they love and then losing the home that person spent his life paying off. This is the trap. This is the slow motion seizure that most families never see coming. Now let me show you what the family thought was safe before the letter arrived. Daniel thought his father had done it right. He thought 30 years on the pipe yard, the early mortgage paydown, the pension, the $94,000 of savings, the paid-off house. That was the family plan. He thought the plan had worked. Lillian thought the nursing home social worker had explained everything. She thought Medicaid was a gift from the government for families like hers. Michael thought the state would not come after a paid-off house. He thought Robert had earned the right to leave his home to his children. Margaret thought she and Robert were going to grow old in that house, that the kids would inherit it, that everything had worked out the way they had worked for. She thought the Saturday morning coffee in the kitchen, the view out the back window, the backyard oak tree Robert had planted in 1994, all of that was safe. None of them understood the estate recovery trap, and none of them were told about it before Robert signed the Medicaid application for long-term care. That is what the system hides. It hides the biggest cost right at the moment the family is most grateful for the help. Now let me show you the strategies that real families with real estate planning attorneys use to keep a paid-off home in the family. These strategies are real. They are legal. They are used every day. They are not available to everyone, and they are not free, but they are vastly cheaper than losing the house. Strategy 1. The Medicaid Asset Protection Trust, often called a MAPT. In plain English, this is an irrevocable trust that you create and put your house into while you are still healthy enough to do it. Once the house is inside the trust, it is no longer counted as your asset for Medicaid purposes after the 5-year look-back period has passed. You cannot take it back out. You lose direct control of the house, but you get to choose who lives in it and who eventually inherits it. MAPTs are a well-known tool in Texas elder law. Attorney fees for setting one up for a primary residence often run somewhere in the $5,000 to $15,000 range, plus possible trustee and filing fees. The 5-year clock must satisfy before the applicant can rely on the trust to insulate the home from estate recovery. Strategy 2. The Lady Bird Deed. In plain English, this is a special kind of deed allowed in Texas, Florida, and a handful of other states, sometimes called an enhanced life estate deed. It transfers the remainder of the house to your children at the moment of your death, but you keep full control during your lifetime. You can live in the house, you can sell the house, you can refinance the house. The house bypasses probate at death. And in many cases, the Lady Bird deed keeps the house outside the reach of Medicaid estate recovery because the house no longer belongs to your estate at the moment of death. A Lady Bird deed does not protect against the 5-year look back if you also need to apply for Medicaid before you die. But for the estate recovery problem specifically, in the states that allow it, it is one of the most powerful, cheapest tools on the table. Strategy 3. A properly structured life estate deed. In plain English, you give your children the future ownership of the house, but you keep the right to live in it for the rest of your life. A traditional life estate deed has its own Medicaid complications. The remainder interest can still be counted in some eligibility calculations, but with proper drafting, it can help in certain circumstances. Strategy 4. Spousal protections. If your parent is married, the well spouse has legal rights to keep a portion of the assets and to keep the house during their lifetime. The Medicaid spousal impoverishment rules keep the well spouse from being thrown out of the home. They do not protect the house after the well spouse dies, but they buy time. Strategy 5. Caregiver agreements and personal services contracts. These are written agreements between the parent and an adult child for care. They have rules. They can be challenged. But in the right situation, they can convert a family gift loophole into a fair market value transaction. Strategy 6. Promissory notes and certain annuity structures inside the look-back window. These are narrow tools that elder law attorneys use in specific situations. They are heavily scrutinized and tightly limited. Now let me give you the most important sentence of the whole video because it ties all of these tools together. The law protects the family that plans 5 years before they need it. The law punishes the family that waits until the ambulance is already at the door. That is the truth the nursing home social worker will not say. That is the truth the hospital discharge planner will not say. That is the truth the average financial advisor has never even heard of. The window is 5 years. The window must close before the Medicaid application is filed. If you wait until the crisis, you lose. Now let me show you the case of a family who did plan. A fictional version of what every well-planned family looks like, and I want you to feel the difference. Let's go 5 years into the past. Robert is 65, Margaret is 64. They sit down with a qualified elder law attorney in Houston. The attorney explains the estate recovery trap. The attorney explains that if Robert ever needs long-term care, the state will come after the house. The attorney recommends a Medicaid asset protection trust. Robert transfers the house into the trust. He names his 3 children as beneficiaries. He keeps the right to live in the house for life. He pays roughly $10,000 in attorney and trustee fees. 5 years pass. Robert is 70. Alzheimer's hits. Robert needs a nursing home. The family applies for Medicaid. The state reviews the past 5 years. They see the house was transferred into the trust 5 years and 4 months ago. The look-back period has expired. There is no penalty. There is no claim on the house. Robert gets Medicaid. The house stays in the family. That is the same Robert Castillo. Same Alzheimer's, same nursing home, same Medicaid. The only difference is 5 years of planning and a roughly $10,000 attorney fee. The difference between losing $312,400 of family wealth and keeping it. Now I want to be honest with you. Not every family can do a MAPT. Not every state allows a ladybird deed. Not every asset can be protected. If the parent is already in the nursing home and the Medicaid application is already filed, it is too late for some of these tools. But it is not too late for all of them. There are still moves, there are still hardship waivers, there are still probate strategies. The only family that is truly lost is the family that does nothing. Now let me give you the tonight action plan. These are the steps that you can take right now, tonight, before the ambulance, before the diagnosis, before the crisis. Step 1, write down what your parent owns: the house, the IRA, the bank account, the car, the savings. If your parent has a paid-off home, write down the estimated market value. Step 2, write down the name of the state your parent lives in. Different states have different rules. Texas runs Medicaid Estate Recovery aggressively. California also runs it with some differences. New York has its own exemptions. Ohio has its own exemptions. Florida has ladybird deeds. Drop your state in the comments right now and I will tell you the specific flavor of the rule where you live. Step 3, find a Medicaid, planning, or elder law attorney in that state. Not a general family lawyer, not a financial advisor at the bank, not a CPA who has never read the Medicaid manual. A real elder law attorney who has done hundreds of these cases. The National Elder Law Foundation Directory, your state bar's elder law section, and local law school clinics are all places to start. The first consultation is often free or low cost. Step 4, if your parent is healthy and over 65, ask the attorney about a MAPT. Ask about a ladybird deed if you live in Texas or Florida. Ask about a life estate deed. Ask about the 5-year look-back issue. Do not let the attorney tell you to wait. Time is the enemy in this fight. Step 5. If your parent is sick and the clock is already ticking, ask the attorney about emergency planning. There are still tools. There are still exemptions. There are still hardship waivers. But only if you move today. Step 6. Add the children to the plan. The most common mistake I see is that one adult child makes all the decisions alone. That creates family conflict. That creates mistakes. Bring the family into the conversation now. Step 7. Keep paying the long-term care insurance premiums if your parent already has a policy. Long-term care insurance, when it is in place before a diagnosis, is the single best hedge against the Medicaid trap. A good policy can pay $150, $250, even $400 a day for nursing home care. That money keeps the parent out of the Medicaid system entirely. That money never triggers estate recovery. Step 8. If your parent is already on Medicaid and has died and the state has already sent a letter, do not panic. Call a Medicaid planning attorney. Many states have hardship waivers. Many states will negotiate. Some states will reduce the claim. Some states will accept a partial payout. Some states will let the heirs buy out the claim by taking a mortgage on the house. The game is not over. Step 9. Stop telling yourself that your family is the exception. Almost every family that loses their paid-off home to Medicaid estate recovery thought they were the exception. Robert Castillo thought he was the exception. He had paid off the house. He had worked 30 years on the pipe yard. He had done everything right. He was not safe. Step 10. Share this video with one family member tonight. The most common barrier in this fight is silence. The most common cause of family wealth loss is the family that did not talk about money. One share can save one house. Now let me bring you back to Margaret Castillo for one last scene because this story is not over for her yet. After the letter arrived, Margaret did what a lot of families do at that exact moment. She called a Medicaid planning attorney in Houston who had been recommended by a friend from church. The attorney was honest. He told her that in Texas, a hardship waiver could be filed if the heirs could show that collecting the full claim would leave them destitute. He explained that a partial payout might be negotiated. He explained that probate would give her time. The attorney also told Margaret something that haunts me. He said, "Mrs. Castillo, if your husband and you had walked into my office 5 years ago, this house would still be fully in your family's name." Margaret cried, not because the house was gone yet, but because she understood that the system is not designed to warn you. It is designed to wait for you. The system looks grateful and helpful while you are sitting at the hospital bedside and then comes for your house after the funeral. That is the truth. That is the system. That is what I am trying to give every family in America the chance to know before the letter arrives. Now, if you made it to this point in the video, you are the kind of person this channel is built for. Subscribe right now because we put out a new deep dive every single week on the hidden rules that quietly take family wealth. Turn on the bell, hit like, and tell me your state in the comments because the rule is different in every state and I want to know where you live so I can make videos that match your situation. I also want you to tell me something else. Has your family ever had a moment where they thought the house was safe and then found out it was not? Tell me your story in the comments. Tell me your state. Tell me what happened. Those stories are why this channel exists. Robert Castillo worked 30 years on a pipe yard to pay off his house, his overtime, his pension, his savings, his love. That house was supposed to be the Castillo family's legacy. Instead, it is now the centerpiece of a Medicaid claim that will quietly pass through probate, eat into the equity, and leave his 3 children with a fraction of what they thought was theirs. That was not a one-time accident. That is the system operating as it was designed to operate, and the only people who learn the truth before the letter arrives are the people who refuse to wait. Do not wait. If your parents own a paid-off home anywhere in America, save this video, share this video, and make a phone call tonight. The window is 5 years, the clock is already running, and the only question is whether you get the letter before or after the funeral.